2014 at 22 hours 47 seconds, as well as on the 15th of October 2014 at 17 hours 33 and 57 seconds between Mrs. Kelly Khumalo's number and the calls received from other parties. Now, Lieutenant Colonel Steyn locates the two calls which are said to have been made by accused number 5 to Mrs. Kelly Khumalo, also at the same time as those reflected in the section 205 as testified to by Ms. Faye-Fillingham in paragraph 1.3. Now, in cross-examination of Ms. Faye-Fillingham, who testified that she's a supervisor in the forensic license services section at Vodacom by counsel for accused number 3, on the point whether section 205 data reflects the two calls mentioned in pages 23, 26, and 27 of Lieutenant Colonel Steyn's affidavit as having been made by accused number 5 using the cell phone number 0733059202 to Ms. Kelly Khumalo and on her number ending with 4358 on the 2nd of August 2014 at 22 hours 47 and 15 October 2014 at 17:33:57 respectively, in paragraph 1.4. Now, in cross-examination by counsel for accused number 3 of Ms. Faye-Fillingham as whether she can confirm that the two calls are reflected in the section 205 data from Vodacom, which, as I've mentioned, is exhibit J1. She answered that the section 205 data does not show the two calls and therefore that she is unable to confirm them. And thereafter, it was put to her that accused number 3 has given instructions, and it was initially put as high as that criminal charges will be contemplated. However, later, this was then put as follows, that a complaint will be contemplated against the compiler of the affidavit. Now, my Lord, we submit that this is a very serious allegation that must be investigated. If there's a suggestion, as counsel put it, that there was impropriety on the part of Lieutenant Colonel Steyn, we submit, my Lord, that it is incumbent upon the state to put those allegations to Colonel Steyn, and he be given the opportunity to comment on those allegations. And my Lord, this is the reason why this application is being brought, in order for Lieutenant Colonel Steyn to come and clarify the nature of these two calls that accused number 5 is said to have made to Ms. Kelly Khumalo. In other words, as to whether they were made using data or internet connection, or whether they form part of incoming and outgoing call data, which Ms. Fathillingham referred to as AMA data in paragraph 1.6. My Lord, we mentioned that the role of Lieutenant Colonel Steyn as an analyst might have been misconceived. He testified as follows in cross-examination by Advocate Mshololo on the question as to how he established that the various numbers that he mentioned in his affidavit as being associated with accused number 5. And this we see on the record of the 1st of August 2023, page 6, lines 16 to 20. He testified as follows, and we quote his evidence. That is correct, but also, I can also mention, after I received the information from Brigadier Gininda, I throw it into the AMB notebook database, and then the linkages come with the section 205s and the cell phone downloads. And in a question asked in clarification by the court about his role as an analyst, he then put it clearer as follows, and this appears on record of the 1st of August 2023, page 11, lines 10 to 16. The court asked the question, that was during the cross-examination by Advocate Mshololo. Because, like he says, when I understood him to say that the investigation is ongoing and giving him as an analyst, or given that he's an analyst, some of the downloads, even the section 205, and he uses that information to try and identify the persons who are associated with the numbers, which they found from the downloads. The court asked Colonel Steyn, am I correct? And Colonel Steyn answered, that is correct. And my Lord, that is the nub of his duties. He's an analyst. He's giving information emanating from section 205, and Ms. Fathillingham explained the process that they generate the information PDF format, but when it's given to the technical support unit of the police, they're able to convert that to Excel spreadsheet in order to do the analysis. In paragraph 1.8, we therefore, my Lord, respectfully submit that the state ought to be allowed to recall Lieutenant Colonel Steyn to clarify the issue of the 2 calls, to clarify whether the source of information of the 2 calls is cell phone downloads or section 205, and also to clarify the information that appear on pages 26 and 27 of his affidavit, and the use of terminology such as MTC and MOC in his affidavit, which, as we have seen, my Lord, the terms are used in the section 205 data. Paragraph 1.9. Now, when the state re-examined Lieutenant Colonel Steyn, also during the proceedings of the 1st of August 2023 at pages 14 to 15, the In re-examination, the state posed the following question, and we quote, "You were asked by Advocate Mshololo as to how you established that that number, which ends with 202, and the complete number is 073-305-9202, made contact with the number belonging to Ms. Kelly Kumalo, ending with the number 4358. You testify that you used the information derived from the investigating team as well as your own searches. Can you just clarify the court as to what those searches entailed?" Then Colonel Steyn answered as follows: "I took the SAP, the section 205. I can show that to the court. This is the way we receive it from the service provider, and we throw all this information in a central database, and then on my AMB notebook program, I can go for a search. Then I put it in the number which I received from the investigating team. I can put in any number. Then the program will pick up the number and point it out to me. Just for the purpose of the court, here I highlight that one extraction of my statement. There is a number mentioned. You can actually see just the number before this one. She did make contact with Senzo. And even if you go a few up, you will see she did speak to Zandile as well. So it is definitely her phone number which she used to contact her friends. And that concludes that portion of his evidence. In paragraph 1.10, we submit, my lord, that it is essential that Lieutenant Colonel Steyn be recalled in order to clarify these aspects so that the truth can be determined, and thereby enabling the court to arrive at a just decision on the case. And we submit, my lord, that there might be fail of justice if such explanation it's not considered. And in paragraph 1.12, my lord, we mentioned that this evidence, it's not about being favorable to the state or the defense, but about the truth being determined in order for the court to arrive at a just decision on the case. The court has been at pains to explain the duties of the state, the duties of a prosecutor, namely to put all relevant evidence before the court that will enable the court to come to a just decision on the matter, and not only incriminating evidence, but all evidence, my lord, that will assist the court in arriving at a just decision. And, my lord, it pains the state if there's a suggestion that we would have put evidence that is improper before the court. And it is for this reason, my lord, that we want to put the matter beyond doubt. If the explanation is in favor of the accused, by all means. But the state, my lord, would like to the correct interpretation of his evidence to be put on record. Paragraph 1.3. We mentioned that the explanation by Lieutenant Colonel Steyn might foreclose the request of accused number 3, or the instruction to his counsel, the charges or a complaint be laid against the compiler of the information, and that we submit, my lord, will save the scarce state resources. In paragraph 1.14, we mention, my lord, that the factual metrics of this case will assist in determining the existence of any motive should this become necessary for the commission of the crimes in question. Hence, it's important that the issue of the calls be resolved. Paragraph 1.15, we have tried, my lord, to look at the relevant authorities or the relevant procedures in the Criminal Procedure Act regarding the recalling of a state of a witness. Looking at some other jurisdictions, especially in the UK, it's based on the rule of practice to ensure that justice is done. We mentioned that it is neither the re-examination of a witness as provided for by Section 166 of the Criminal Procedure Act 51 of 1977. It is more based on Section 173 of the Constitution, Act 108 of 1996, which states that the Constitutional Court, the Supreme Court of Appeal, and for our purpose, the High Court, have the inherent power to protect and regulate their own processes and to develop the common law taking into account the interests of justice. So the interest of justice is a prime consideration in deciding whether a witness should be recalled. And this power is already vested in Section 167 of the Criminal Procedure Act, which states that the court may, at any stage of criminal proceedings, examine any person other than the accused, and may recall and re-examine any person already examined at the proceedings, and shall examine or recall and re-examine the person concerned if his evidence appears to be to the court to be essential for the just decision in the case. We have come across a case, my lord. It's not really on point. It's more about the leading of new evidence after the state has closed its case, but we submit that the principles are equally applicable. And this is the case of State versus Felthun. Is F-E-L-T-U, I'm sorry, T-H-U-N, Felthun, and is a decision of the Supreme Court of Appeal. It's recorded in the 1999 Volume 1 SACR at page 481. And this case was concerned with the presentation of new evidence after both the state as well as the defense cases have been closed. And at paragraph 486 I'm sorry, page 486, paragraph B, the SCA remarked as follows: the first question which thus arises for decision in the present case is whether the trial court ruling allowing the reopening of the state case constituted an irregularity. And as I mentioned, my lord, this is in the context of reopening of the state case to present new evidence. But the principle distilled in this matter is equally applicable to an instance where the state seeks to lead evidence to rebut the type of assertion or complaint that was leveled or intended to be leveled against Lieutenant Colonel Steyn. In paragraph C, the court held that a trial court has a general discretion in both civil and criminal cases to allow a party who has closed his case to reopen it and to lead evidence at any time up to judgment is beyond doubt. So the court here, my lord, mentioned that up to the judgment state, a party is allowed to present evidence on the proviso that a proper application is made, as the state is currently doing.
No, yeah, but I hear you.
Yes.
But the SCA also says that the case you're quoting is after argument. Is that not so?
Yes, yes.
In other words, the state leads evidence, cross-examination by the defense, close your case, the defense leads evidence, cross-examination, you closed, the defense case is closed. Then the parties argue. They argue. All the two parties argue. They say, the SCA says, even after the parties have argued,
Yes.
you can apply for a reopening
Indeed.
of
Yes.
either of the cases
Yes, indeed.
and re-lead evidence, even new evidence.
Yes.
Unlike in this case, for instance,
Yes.
there is no argument which has been proffered by the state after its case was closed, etc.
Yes, indeed. We, in fact, still busy with the state case.
Okay, fine. Now I'm just saying
Yes.
it can even be done so that we are all at idem,
Yes.
even after argument,
Yes.
in exceptional cases. That's what the SCA says.
Yes, indeed, Malok.
Okay, fine.
That is what the SCA held in this matter. And the court then went on to hold that the proper approach is that the court's discretion should be exercised judicially upon a consideration of all the facts of each particular case, having due regard to the considerations mentioned in the cases and applying them as guidelines and not as inflexible rules. The court then referred to the case of Mkonazi versus Van der Merwe and another, 1970, volume 1, essay 609. Also the decision of the then appellate division, where Holmes J.A., as he then was, held the following at paragraph 616b to d, says, it is inappropriate for judicial decisions to lay down immutable conditions which have to be satisfied before the relief sought can be granted. Over the years, the courts have indicated certain guiding considerations or factors, but they must not be regarded as inflexible requirements or as being individually decisive. Some are more cogent than others, but they should all be weighed up in the scales, the pros against the cons. Then the majority of the court in that matter held that on the facts of that case, that fresh evidence should have been admitted by the magistrate after both sides had closed their cases, even though there was no satisfactory explanation as to why the evidence had not been led before. So we have earlier on debated the issue of new evidence being admitted after argument has been presented. But here in the Mkonazi case, the court said even after the close of the case for the respective parties, new evidence may be admitted. Then at paragraph I on the same page, the court held, referring to Wigmore on evidence, that nevertheless, situations might easily arise in which an honest purpose may justly be served without an unfair disadvantage, but meeting evidence at this stage, and it is always, or it has always been considered that the trial court's discretion should not be hampered by an inflexible rule. So at the end of the day, my lord, it's the trial court that has got a discretion, and these decisions that I've just referred to have held that this discretion should not be unduly limited.
Yeah, but still, even though we know that the discretion, which also arises from Section 186,
yes,
must be used judicially and very sparingly, but the defense still have an opportunity to cross-examine Steyn.
yes.
It's not like the court, if it does, it's not like the court admits the application on behalf of the state that the state should recall Steyn.
Yes.
General principles apply also that even after that, having led Colonel Steyn to explain whatever you want him to explain, the defense has got the right to cross-examine Steyn and put the version of their clients regarding that evidence of terrification.
Yes, indeed, and that speaks to the issue of prejudice, my lord, that there will
Yes.
be no prejudice since the defense will be allowed to cross-examine Colonel Steyn.
And the defense also has the right to rebut that evidence by also calling
Yes.
a witness who will rebut the very evidence you're saying you want to recall Steyn to come and adduce before this court.
Yes, indeed, my lord.
Okay.
Then paragraph J, this on the same page, the court then held that with regard to the test to be applied to an application to reopen, the considerations mentioned by the court include the following. One, the reason why the evidence was not led timelessly, and we will address that shortly. And secondly, the degree of materiality of the evidence. We've already mentioned, my lord, that it is important that this issue be cleared up. It might help to resolve the issue of motive if the issue is satisfactorily explained. But more importantly, it's important to know as to what happened. Were there such calls, or as Steyn testified, or did he perhaps make an error? And it's for him to come and explain that, my lord.
No, but what I'm interested in also, if he allegedly did make an error, was it picked up by the defense, for instance, that your evidence does not make sense or it's incorrect?
Well, looking at the cross-examination, in fact, it just focused mainly on the source of the numbers. You know, it did not really go to the heart of the issue that the court is raising. It was not seriously contested or put in Fillingham.
So in other words, if I understand you, are you saying Colonel Steyn was never pertinently told that he has tampered with the evidence, he has created evidence or manufactured evidence and materially changed it to such an extent that it borders on fraud?
Yes.
Was it ever put to Steyn?
No, that is why, my lord, we're saying that it's important that he should come and answer to the allegations that has been put to Ms. Fillingham.
So the allegations are put to Ms. Pinky Fillingham, who is not a compiler of that document.
Indeed, my lord. And as we've mentioned, that it's important that the compiler of the information, and this Lieutenant Colonel Steyn himself, that he should come and respond to those allegations. They cannot be left unchallenged on record and forever remain as a question mark regarding his evidence. He can easily just come and explain those two calls, and whichever way the explanation goes, that will be in the interests of justice, my lord, because that will help the court to then arrive at the truth.
But doesn't this impinge on reputational damage? Because Steyn and
Ms. Fillingham, yes.
But these are said to be expert witnesses.
Yes.
And if it is put to them that they are contriving evidence, they've tampered with evidence, they've fraudulently planted evidence before this court, don't you think that impinges on reputational?
Yes. Yes, well, indeed, my lord. The police on a daily basis, they analyze information received from network providers,
Yeah.
and it is important that the court should be able to rely on their evidence, and it is therefore important that this issue be explained. And also, as I mentioned, my lord, that the state would also not be party to any evidence that is improper. We would also like to have this issue clarified so that the state can then be convinced that it presented evidence, my lord, that is free from any doubt, any impropriety, and it's important, my lord, that that issue be clarified.
If I recall, Mr. Nisi said the intent preferring a complaint, a charge of fraud, perjury, uttering and blah, blah, blah. You remember that?
Yes.
What was the submission by Mr. Nisi?
Yes, all involved, not only against the compiler, but apparently against
even the state,
all the state,
the prosecutors themselves.
Yes, that's how wide-ranging that and breathtaking that allegation is. Then at page 487, the courts then laid out the criteria to be applied. I've already referred to the reason why the evidence was not led timelessly. The degree of materiality of the evidence, that is what we've just debated. The possibility that it may have been shaped to relieve the pinch of the shoe. This is precisely what we've just debated. The possible prejudice to the other side, including such factors as the fact that the witness who could testify in rebuttal may no longer be available. In this instance, we're in the fortunate position that even if Lieutenant Colonel Steyn has retired, he has made himself available. And then the stage which the proceedings have reached, and the general need for finality. We are at a point where the state case has not yet been closed, and we submit, my lord, that as we did earlier on, that no prejudice will be suffered, as the defense will have the opportunity to cross-examine the witness and also lead evidence in rebuttal. Then coming back to our heads, on paragraph 2 of page 4, the explanation as to why the evidence was not sufficiently clarified in evidence in chief, in paragraph 2.1, my lord, we mentioned that these are highly technical issues, and Lieutenant Colonel Steyn, that in his evidence, these issues might not have come out as clearly as to what the source of the two calls was, whether they were data or internet calls, or normal incoming or outgoing calls, or AMA data, as we've mentioned. And with the benefit of Ms. Fathilingham's evidence of how incoming and outgoing calls are captured on the network, the NEMO, we submit that it is essential for Lieutenant Colonel Steyn to put his evidence in its proper perspective. In paragraph 2.2, we mentioned that, and this the issue that has already come up in the debate, in cross-examination of Lieutenant Colonel Steyn, there was no suggestion that page 23 of his affidavit is false, and we submit that it's only fair that he must get the opportunity to comment. Then, my lord, we deal briefly with the interest of justice. We submit that it is in the interest of justice to allow the state to recall Lieutenant Colonel Steyn to clarify the source of the two calls. We refer to the case of R versus Hepworth, 1928, AD 265 at 277, which has previously been debated before this court, wherein the court held that criminal proceedings are not a game in which one side is entitled to claim the benefit of any omission or mistake made by the other. The duty of the trial judge is not only to direct and control the proceedings according to the recognized rules of procedure, but to see that justice was done. We also refer to the case of State versus Sheikh and others that we have previously referred to, reported. We give the citations there. 2008, Volume 1, SSCR, page 1, decision of the Constitutional Court, given on 2 October 2007, where the court held as follows, and we quote, "The applicant stressed that they place their reliance on the general right to a fair trial, which, as this court has held, extends beyond those specific rights enumerated in subsection 35(3)(a) to O of the Constitution. The right to a fair trial requires a substantive rather than a formal or textual approach. It is clear that fairness is not a one-way street, conferring an unlimited right on an accused to demand the most favorable possible treatment. A fair trial also requires fairness to the public as represented by the state. It has to instill confidence in the criminal justice system with the public, including those close to the accused as well as those distressed by the audacity and horror of crime. Then we lastly refer to the case of multi-choice and others versus the National Prosecuting Authority, and and we give the citation there where the Supreme Court of Appeal, per the current JP of this division, then he was attached to the SCA, he had as follows. Our Constitutional Court has been vocal regarding the protection of the right to a fair trial. Indeed, any accused person who appears in a court of law facing any charge has the constitutionally guaranteed right to a fair trial, which includes the foundational values of dignity, freedom, and equality, which are central to a fair trial. And reference was made to the case of State versus Jugus and others, wherein the court confirmed that the right to a fair trial is a comprehensive right and embraces a concept of substantive fairness, and that at the heart of the right to a fair trial, fair criminal trial, and what infuses its purpose is for justice to be done and also to be seen to be done. And in S versus Dlamini and others, we give the citation there where the then Constitutional Court, Judge Krichler, described the phrase interest of justice as a useful term denoting in broad and evocative language a value judgment of what would be fair and just to all concerned. It is therefore respectfully submitted that the state be allowed to recall Lieutenant Colonel Steyn. We've already mentioned, my lord, that the state will never be party to any evidence that is contaminated, that is improper, and the state will never present such evidence before court. We therefore request, my lord, that this issue be clarified by allowing Lieutenant Colonel Steyn to be recalled. I think that is all.
Okay, Mr. Prosecutor, Mr. Interpreter, can you interpret the gist of the application for the accused?
As a conclusion, lesisicelo lesi sizama ukuthi kuphinde kubuyiswe uLieutenant Colonel Steyn ukuthi azochaza nge-affidavit yakhe khona akuyo ku-affidavit nokunye mhlawumbe kwasho kubufakazi obalethwa nge-affidavit kaMiss Mamuva Tilingana. Futhi-ke i-state-ke ushuthi umshushisi ufuna lokhu ukuthi kuphinde kubhekisiswe kubukezwe kahle ukuthi ingabe kukhona yini ukungahambi kahle noma ungafaki kahle kofakazi obuthize obalethwa uColonel Steyn noma uLieutenant Colonel Steyn, ukuthi-ke akwazi ukuthi azoziphendulela achaze kahle ukuthi kuzwakala ukuthi lo bufakazi ayiletha babufakazi obunjani, futhi-ke nokuthi-ke kususwe-ke ukungabaza kokuthi lo bufakazi obalethwa la kokungekho ukukhwabanisa kulo bufakazi obalethwa la, ukusho-ke ukuthi-ke uma elethwa la enkantolo uzofike aziphendulele ngendlela yokuthi-ke angabuza umbuzo aphinde naye aphendule. Is the court please?
Yes. You said you are not opposing. Yes, then Mr. Nis, it's your turn.
As it is the court,